Live and direct from the MTV studios here in Colombo. This is Primetime News here on MTV Sports. I'm Ramesh Bandara.
And I'm Krishi Pandagaratna. The United National Party requests the Speaker to act according to the Supreme Court orders and the advice the government to formulate new laws with regard to impeachment motions. And now let's take a look at the headlines.
In your headlines tonight, the Supreme Court determines that the Parliamentary Select Committee has no legal power to come to a finding adversely affecting the rights of a judge. The Deputy Speaker says that neither the Parliament nor himself has received the court interpretation. A decision made to release buffer stocks of paddy maintained by the government to the market.
The Court of Appeal read out the determination of the Supreme Court today in relation to several matters which had been referred to the Supreme Court by the Court of Appeal on the interpretation of the Constitution. The Supreme Court had determined that the Parliamentary Select Committee, which examined the impeachment motion against the Chief Justice, had no legal power or authority to come to a finding adversely affecting the rights of a judge.
The petition filed by Chief Justice Dr. Shriyani Bandaranaike challenging the findings of the Parliamentary Select Committee was to be taken up before the Court of Appeal today. Many opposition parliamentarians gathered at the Supreme Court complex in Hulstorf. The petition filed by the Chief Justice was taken up before a bench comprising of Justices S. Srikandraja, Anil Gunaratne and A.W.A. Salam. Before taking up the petition, the Court of Appeal read out the determination of the Supreme Court. The Supreme Court interpretation states that in a state ruled by a constitution based on the rule of law, no court, tribunal or body has authority to make a finding or a decision affecting the rights of a person unless such a court, tribunal or body has the power conferred on it by law to make such findings or decisions. It adds that such legal power can be conferred on such court, tribunal or body only by an act of parliament which is law and not by standing orders which are not law but are rules made for the regulation of the orderly conduct and the affairs of the parliament. The Supreme Court shows that Parliament, by standing orders, provide for all matters relating to the presentation of the procedure for passing resolutions. The matter relating to proof, being matters of law, also will have to be provided by law, and the burden of proof, the mode of proof, and the degree of proof also will have to be specified by law to avoid any uncertainty as to the proof of the alleged misbehavior or incapacity, without leaving room for the body conducting the investigation to decide the questions relating to proof according to its subjective perception. The Supreme Court points out that the preamble to the 1978 Constitution assures to all people inter alia the independence of the judiciary as the intangible heritage that guarantees the dignity and well-being of the succeeding generations of the people of Sri Lanka. The Supreme Court says that on the 20th of June 2001, the late Anru Bandaranaike, the then Speaker of Parliament, had pointed out members of Parliament may give their mind to the need to introduce fresh legislation or amend the existing standing orders regarding the motions of impeachments against judges of the superior courts. The constitutional interpretation was made by a three-judge bench of the Supreme Court comprising of Justices Nimal Gamini Amaratunga, K. Sripavan and Priyasad Deb. A group of attorneys, including President's Counsel K. Kanangeeswaran, S. L. Gunasekara, President's Counsel G. Alagaratnam, and President's Counsel Shibli Aziz, were present at the Supreme Court representing the petitioner.
The Supreme Court has determined this Select Committee appointment is unconstitutional, it is in violation of the Constitution, and the Court of Appeal has now issued notice on all the respondents returnable on the 15th January.
The Supreme Court is the sole authority to interpret the Constitution. No one else has the judicial power to interpret the Constitution. It is clear that the decision and the report of the Parliamentary Select Committee is void before the law and has no power. Meanwhile, lawyers appearing on behalf of parliamentarian Vijitha Herath and R. Sambandhan, members of the Parliamentary Select Committee, were present at the Court of Appeal in connection with the petition filed by the Chief Justice. The three-judge bench refused to grant permission to hear two petitions filed against the petition filed by the Chief Justice. The petition filed by the Chief Justice will be taken up on Monday. Vijitha Herath and R. Sambandhan appeared before the Court of Appeal and said that they would not file objections. Accordingly, the petition will be taken up on Monday. A notice was issued to the Attorney General to appear before court and present facts to the court if he wishes to do so.
Meanwhile, a group including politicians who were present at the Supreme Court premises today expressed their views on the Supreme Court declaration.
The Supreme Court has provided a comprehensive response to the attempts made to show the world that a case was heard by degrading the law and the Parliament and by undermining the laws of natural justice and human rights. As politicians, we should be proud that there is a strong judiciary in the country which can stand firm and say, this is the law, implemented. The Supreme Court has given a clear verdict to the government that this procedure is wrong and that it should be done correctly. They held on to Anura Bandaranaike's report all this time. Incidentally, today the Supreme Court, based on Anura Bandaranaike's report, said that things should be done in a proper manner. We do not accept that this parliament, which has a 2/3 majority, is supreme. It is the public of the country who are supreme. As public representatives, it is our responsibility to ensure the sovereignty of the people.
අද ශ්‍රේෂ්ඨාධිකරණය විසින් ප්‍රකාශයට පත් කළ ඔපීනියන් එක
The opinion expressed by the Supreme Court today is indeed historic. The Supreme Court issued a verdict today that protects the supremacy of the law and the independence of the judiciary, which is essential not only for us but for the future generations as well.
රටේ උපත්ය ලබන්න ඉන්න දරුවන්ට පවා දරුවන්ගේ රැකවරණය සඳහා අවශ්‍ය
Speaking at a media briefing held today, Deputy Speaker of Parliament Chandima Weerakkodi commented on the Supreme Court determination over legal authority of the Parliamentary Select Committee which examined the impeachment motion against the Chief Justice.
පාර්ලිමේන්තුව දැනුවත් කිරීමක් කළා නැහැ. මම මේ නියෝගය මට ලැබිලත් නැහැ මට එහෙම කියවන්න.
The Parliament has not been informed. I have not received the verdict and there is no need for me to read it either. I am only aware about such a verdict through the SMSs sent by you. It is clear that standing orders are not part of the law. Under Article 107 of the Constitution, the Parliament is vested with the power to remove judges of the Court of Appeal and the Supreme Court through the law or standing orders. The Special Committee has not found her guilty of any wrongdoing or has decided to remove her from the post. The final decision has to be made by Parliament. According to Article 4C of the Constitution, the Court has not been vested with the jurisdiction over the Parliament. This is an issue regarding the power of Parliament. If there are any confusion over parliamentary privileges and standing orders, it is clear that we are following and accepting the traditions of the British Parliament. In the history of England, the Parliament has never been summoned to courts and the judiciary has not interfered in proceedings of an impeachment motion taken up by the British Parliament. Similarly, this Parliament too is operating according to such traditions and the precedents of former speakers.
අපේ සම්ප්‍රදායන් පූර්වගාමී කතාව නායකතුමන්ගේ තීන්දුවත් එක්ක මේ පාර්ලිමේන්තුව ක්‍රියාත්මක වෙන්නේ.
United National Party parliamentarian Lakshman Kiriella made a special statement on the report issued by the Parliamentary Select Committee which examined the impeachment motion against the Chief Justice.
The Honourable Supreme Court ruled that the impeachment process on the Chief Justice is entirely unconstitutional and ultra vires. Parliament has the right to make laws, make constitutions, but interpreting laws and constitutions is entirely with the Supreme Court. I remember the Honourable Speaker a few weeks ago made a statement in Parliament where he clearly stated the sole right of interpreting the Constitution is with the Supreme Court and no other. Therefore, what the government should do now is to withdraw the impeachment motion and submit to Parliament new laws for a clear impeachment procedure based on natural justice and fair play.
At the Cabinet media briefing held today, journalists raised questions regarding the stance of the government on the verdict given by the Court of Appeal.
පාර්ලිමේන්තුවේ යම්කිසි ක්‍රියාදාමයක් පවතින ව්‍යවස්ථාව තුළ
The Speaker has followed the procedure laid out in the Constitution to remove a Supreme Court judge. It is a procedure that has been followed throughout history. For the first time, a verdict has been issued that challenges it. A decision can be given once the Speaker takes a decision on the matter.
නමුත් පොදුවේ ගන්න තීන්දුවක් ගන්න වෙන්නේ කතානායකතුමා මේකට යම් තීන්දුවක් දුන්නාට පස්සේ. That is because now we will inform His Excellency the President to, as you all have suggested, study deeper before appointment. Yeah. Right? That you all have suggested that His Excellency has not studied properly the case.
Leader of the National Freedom Front, Minister Vimal Weerawansa, expressed his views on the impeachment motion against Chief Justice at a media briefing held today.
අභියාචනාධිකරණය ඇහුව ශ්‍රේෂ්ඨාධිකරණය මොකද අපි කරන්නේ කියලා. ඒ කියන්නේ හොරාගේ අම්මගෙන් පේන අහනවා වගේ වැඩ ශ්‍රේෂ්ඨාධිකරණයේ උඩ ඉන්නේ.
I am telling the Court of Appeal that there is no problem and that standing orders are not part of the law. Hence the courts have the complete authority to take necessary action. It is clear that the Parliament has the full authority to act based on constitutional matters through the passing of bills and standing orders. This is stated in the Constitution. Chief Justice Shirani Bandaranaike is ignoring this Constitution. We believe that it is apt to appoint a judge who is holding office at the Supreme Court to the post of Chief Justice once it becomes vacant. When such an appointment is made, everybody will know that the government does not have a hidden agenda.
Staying on the subject, former Army Commander Sarath Fonseca vehemently condemns the failure of certain members of the Parliamentary Select Committee to appear before the Court of Appeal. Fonseca expressed this view at a media briefing in Colombo today.
The members of the Parliamentary Select Committee were called before the Court of Appeal today. The members of the government were not present. They did not follow court instructions. Only the opposition parliamentarians from the Democratic National Alliance and the Tamil National Alliance abided by the court order and appeared before the Court of Appeal. It is evident to the people that our parliamentarians who were present in court today respect the law of the country. We believe those who are absent today have a mentality of disrespecting the law and underestimating the law. We condemn these actions.
ඒක අපි තනිකරම හෙලා දකිනවා අපි ඒ தත්ත්වය ප්‍රතික්ෂේප කරනවා.
A protest was carried out in Petta today against Chief Justice Dr. Shirani Bandaranaike.
The protest, which was held opposite the Fort Railway Station, was organized by the trade unions, including the Joint Trade Union Alliance. The power of the people is in Parliament. The judiciary cannot defeat our power. The rules and regulations for the public are formulated in Parliament. Therefore, we reiterate that the power of Parliament should be protected.
Moving on to other local news now, Minister Anura Priyadarshana says that an unidentified person had threatened him over the cell phone. Speaking News First, he said that he had lodged a complaint with the Colombo Crimes Division over the incident.
I came home around 3 o'clock. I think around half an hour later, if I may write, my wife answered a call which came to her cell phone. And she gave the phone to me, saying that one person called Prasantan is asking for me. And I took the phone and I answered him, and he told me that, have you heard about the judgment made by the Supreme Court? And if you ever start to bully our lady, we will take care of you. And I made a complaint to the Colombo Crimes Division, and I wanted to find out who this caller is and why he called me, because it has never happened to me, because normally people don't threaten me. So I consider this as a threatening call.